Hi, this is Josh Blackman, and welcome to the Harlan Institute Virtual Supreme Court Competition. This is the round of 4. This year, we are mooting the case of Moody versus NetChoice, and we have 2 teams. We have Kevin Bisley and Maxwell Steinberg representing petitioners, and we have Nathaniel Marks and Edward Napoli representing the respondents. And now I turn over to my good friend, Chief Justice Tommy Berry, who will be presiding. You may begin.
We'll hear argument next this afternoon in Moody versus NetChoice. Petitioners?
Mr. Chief Justice, and may it please the court. The First Amendment's broad protection of the freedom of speech and expression defends just that, expression. Because social media companies' content moderation cannot be seen as expressing anything at all, Florida is free under the First Amendment to regulate it and compel factual disclosures about how a platform's terms of use are applied.
The First Amendment's guarantee of free speech and expression has made for a nation of free discourse. But the digital world, the new public square, as this court recognized in Peckingham, is a different story. At present, the social media corporations, represented by respondents, hold absolute control over what may be said on their platforms, and with this power, they can silence contrarian views and censor ideas they disapprove of without any accountability. To bring the content moderation of social media companies into the light and curtail unfair moderation practices, Florida passed SB 7072 in 2021. The 11th Circuit found the law to infringe upon the free expression of social media corporations and impermissibly compel speech. We ask the court to reverse the decision below and uphold the law for the following reasons.
Firstly, the content moderation of social media companies is not speech itself, but only the hosting of a third party's speech. Miami Herald and PG&E both concerned cases where editorial discretion was used to determine which speech could be posted in the first place. Under Pruneyard and Fair, which better fit the passive hosting of speech on social media platforms, content moderation is not expressive.
Secondly, the disclosure provisions of the law do not compel expression in violation of the First Amendment. Under this court's precedent in Zouderer, Florida may compel a corporation to divulge purely factual information about the terms under which their services will be available.
Thirdly, the common carriage doctrine allows the imposition of non-discrimination requirements such as SB 7072. In the era of modern telecommunications, it is only sensible that this designation now encompass social media. As SB 7072 requires fair moderation on platforms, it is clearly within the scope of this common carriage doctrine.
And finally, this case comes on a facial challenge, and SB 7072 clearly has a plainly legitimate sweep as applied to platforms like Uber and Gmail.
Counsel, you say that the platforms are passive carriers. Don't we all act like they're making expressive choices? I mean, the very fact that I'm constantly hearing that people having their tweets taken down or whatever is censorship. That seems to be an overt acknowledgement that the choices the platforms are making are expressive, that they are cultivating a message when they decide what to leave up and take down. What do you make of that?
Yes, Your Honor. I don't think there is any clear message here for a few reasons. So first, a message requires not only that the platforms be expressing something, but that would be received by an audience, as in Hurley. And I don't think that's the case here. And secondly, it's an awfully unusual editor that just represented to the court last term in Tamna that they have no sense of what's actually on their platforms. So it's a weird editor to think of that's actively editing that doesn't even know that ISIS is using their platform.
Is there a distinct freedom of editorial freedom protected by the First Amendment, separate and apart from freedom of speech?
So, Your Honor, I think Miami Herald v. Tornillo gets to this point and makes clear that there is a protected freedom of editorial discretion under the First Amendment as sort of part of this freedom of speech. But this freedom for editorial discretion does not apply to social media corporations. As my co-counsel pointed out, there's no clear message that the platforms are expressing, and Hurley makes clear that for an action to be expressive, it needs to convey some sort of message to its audience and to its listeners. And for a reasonable observer on these sorts of social media platforms, they would not necessarily know what message, if any, is supposed to be conveyed here. So, well, there is that freedom of editorial discretion that would not apply in this particular case.
Does a newspaper, if a newspaper prints op-eds of diametrically opposing points of view, does it still have editorial freedom under the First Amendment?
Yes, Your Honor. So if a newspaper's publishing 2 op-eds under opposing points of view, the the message of the newspaper might be along the lines of, here are two different opinions on this matter, and we think both of these opinions are important to consider, and our message is that we want readers to weigh both of these opinions and sort of decide what they think between them.
If we find that there is an independent right of editorial control through Miami Herald and Hurley and Halleck, and that it does apply here, do you lose? Or do you think you can overcome strict scrutiny? What happens then?
We do not think that we can overcome strict scrutiny, Your Honor, but we do believe that this court were to subject certain parts of this law, because we think this court should go through provision by provision to really march it all out and see what parts of the law can be constitutional. And since the law does have an express severability clause, adhere to that. But we think that if it's going to be subject to strict scrutiny, no, it cannot pass muster. But under intermediate scrutiny principles, we think we can advance the same interest that this court allowed for in CBS broadcasting, and also in Turner, in an interest in hearing a plethora of information sources, and also giving individuals access to candidates running for Democratic office.
Counsel, I got to say, it's a little odd to me that you're saying that one can't figure out any message that these platforms are trying to send through what they publish and don't publish. I mean, isn't the whole reason that your state government and so many other people are wanting this kind of law because they don't like the messages that they're not allowing through, because they don't want those on their platforms? I mean, isn't their effort to craft a message the whole reason we're here and talking about this?
So no, Your Honor. I think there are 2 points to get to on that. Firstly, sort of what the purpose behind SB 7072 is, and then secondly, sort of the alleged message of the social media corporation. So you're going to the purpose of SB 7072. You're looking at the text of the law. It requires content moderation to be done neutrally and in a fair way under the terms of service, and it imposes some restrictions on how journalistic enterprises and political candidates can be moderated. And this doesn't really require a message of any sort, nor is it a direct reaction to any sort of disfavored message. And while I do recognize that there's the signing statement from Governor DeSantis that may sort of raise some questions for the court, Governor DeSantis isn't speaking on behalf of the Florida legislature here. There were, I believe, 22 senators, 78 representatives who voted for this law, all of whom may have had different intents, and it's really impossible to come up with a coherent legislative intent beyond to enact the text of the law. And from the text of the law itself, we can't really find any purpose beyond to sort of require that content moderation be fair to the users of the platform. And then getting to the sort of second point on the alleged message, I know respondents mentioned in their brief that they believe their message to be inclusivity and tolerance in their content moderation, but that's a bit hypocritical, I would say, because it's essentially akin to saying, because our message is inclusivity and tolerance, we are going to exclude speech that we don't tolerate by censoring it. And so it's a bit incredulous to presume that that is in fact the message being expressed by social media companies here, because their actions directly contradict that message.
But I mean, with that, aren't you just telling me that you think that they do a bad job of it? That if you wanted to be inclusive, there's another way you should go about it. But who is the state of Florida to second guess how they craft their message of tolerance, how they go about, adjusting what appears in people's feeds to better reflect their values and the kind of message they want their platform to present? Aren't you just second guessing them in a way that would seem inappropriate for the government to do under the First Amendment?
Your Honor, we think that at its heart, this law is a consumer protection measure. So what it really means is that all of these different paradigmatic social media companies that we're talking about can craft their own policies. All that we're saying is that all that Florida is requiring is that the way they actually enforce those policies is how they hold themselves out to enforce them. They hold themselves out as being open for all viewpoints. They hold themselves out as widely open to the public, and that's how they get Section 230 protection. So basically, the social media companies are attempting to speak out of literally all sides of their mouth at simultaneous times, and I don't think the court should indulge that fantasy.
Would a newspaper that held itself out as open to every viewpoint lose its First Amendment rights?
I think that a newspaper is an entirely different example because there, as the district court acknowledged, there's substantive review of everything that's published. So if you're reading something in the newspaper, you know somebody from the newspaper read it and was like, hey, we want the readers here to see this, to acknowledge it, to read it. It's entirely different here with millions and millions of posts every single day that don't have any sort of front end review. So there's no message attributable to the social media companies. It's individual speech. It's not that of Twitter or Facebook or Instagram. It's individual people's speech, which is how they get Section 230 protection to begin with.
All right,
Thank you.
thank you, petitioners. Your time's up. Respondents?
Mr. Chief Justice, and may it please the court. Florida presents arguments today to justify SB 7072 as a valid regulation of the conduct of social media platforms. But in fact, the bill impermissibly violates the editorial discretion rights of the platforms, compels speech in an unduly burdensome manner, and is permeated with the purpose of anti-speech discrimination. Petitioners' arguments that these platforms are akin to speech hosts or common carriers hold no water.
The right to editorial discretion established in Miami Herald applies not solely to newspapers or other publications, but to any organization that tailors third-party speech, as applied in Hurley and extended further in Arkansas Commission. Private entities may exercise editorial discretion over private forums that they manage, as held just 5 years ago in Manhattan Community Access Corporation. The content moderation actions of social media platforms are sufficiently imbued with expressive purpose as to be protected by the First Amendment, and they cannot be regulated as normal business conduct.
SB 7072's provisions squarely violate the standards for compelled speech outlined by Zotero. By compelling individualized explanations for each of the thousands of moderation actions taken each day, SB 7072 is without a doubt unduly burdensome. The requirements that such explanations be precise and thorough are so broad that the results cannot be purely factual or uncontroversial. Mandating speech that would otherwise not be said necessarily changes the content of the speech that is said, and in doing so is unconstitutional.
SB 7072's express purpose is the regulation of platforms considered by the government of Florida to be left-leaning, as was stated by the governor, lieutenant governor, and numerous state legislators. When a law's purpose is to suppress certain speech, the law is invalid, even if the law seems to be facially constitutional, as Turner. Even O'Brien held that the government's interest behind a law affecting speech rights had to be unrelated to the suppression of speech itself.
Petitioners' speech host precedents do not provide a solid basis for their arguments. While Pruneyard did compel a mall owner to allow pamphleteers on his property, it did so only because the mall owner's objections to pamphleteering were entirely unrelated to his personal views, meaning that the action to remove pamphleteers were not imbued with speech. Rumsfeld did mandate that universities host military interviewers, but only in the context of a federal funding provision, and only then because there is no way that the hosting could be interpreted as an endorsement of military activities.
One of the basic qualities of common carriers is that the carrier be open to all comers without qualification. However, it's well known that platforms moderate content on their sites, and users agree to abide by the moderation decisions of the platforms when they create accounts. The public interest standard for common carriers was repudiated in Nebia, showing that the standard cannot be used to determine common carriage. Social media platforms have many competitors, proving that they're not monopolies in their sectors. And finally, while platforms may receive some government protection in the form of Section 230, government favors have been granted to many companies without making them common carriers in the past.
SB 7072 is an unconstitutional restriction on editorial discretion, an unduly burdensome compeller of speech, and a discriminatory regulator of speech-imbued conduct. Neither speech host nor common carrier justification is supported. We therefore ask the court to affirm the 11th Circuit and uphold the preliminary injunction. We welcome the court's questions.
Counsel, I don't really see how any of these precedents do us much good in figuring out how to regulate or not regulate or allow, I should say, regulation of a many-to-many communication platform. So you rely heavily on Halleck, for instance, community access cable. They can only carry so much content. They may have to make editorial choices. How is social media not just something completely new, something more like a public accommodation that we should be thinking about everybody having a right to use?
Well, Your Honor, I think it's important to remember, as held in Minneapolis Star, that you can't just take the size of a certain speech, a certain private forum, and say that because it's of a certain large size, it lacks some of these fundamental rights.
Well, to be clear, I'm not talking about the size of the company. I'm talking about the size of the forum, of the medium. It looks to me a lot more like, say, a telephone than a newspaper.
While these are, Your Honor, while these are large size forums, the size still does not change the fundamental rights of these organizations. Halleck's stated principles about private forums and editorial discretion in broad terms, understanding that it didn't solely apply to community access cable corporations, but to private forums as a general matter. And a private forum is still a private forum, no matter how large it may be. It could be just a local community access corporation, or it could be a very large social media platform, as in this case.
Well, it seems like that kind of begs the question, because the whole issue is it a forum that the host is exercising some kind of expressive message over? I mean, even the parade in Hurley, that's at least loosely organized around St. Patrick's Day. What about the hosting here makes for expression by the social media platform?
Well, Your Honor, we'd like to say that the moderation decisions of the platforms themselves are an inherently expressive action, as in people are using these platforms on a day-to-day basis and being fed content through the way that these platforms moderate their speech. So it is basically an inherent expression of the platform's speech as to what they want to display to their users. So we think it fits within that narrative there.
And also, Your Honor, as held in Hurley, there need not be a single unified message in order for editorial discretion rights to be applied. It's not necessarily that social media companies tailor every post to provide, some particularized message of inclusivity or diversity, but rather that they have these kinds of purposes and speech imbued in the actions that they take. It's not necessarily the outcome that's as important in this case, but rather the means and whether those are imbued with speech. And we believe that they are in this case.
What if there's a social media site that has never moderated anything, basically something like 8chan, anything goes? Does it still have some sort of expressive right, or has it lost it through its own choices?
Well, Your Honor, if it's not regulating anything at the time, then at the time, I suppose it would not have those discretion rights. Of course, it wasn't editing anything. But if it is a private organization managing a private forum, then it still retains those editorial discretion rights, whether or not they're exercised on a regular basis. It doesn't matter if I went to a protest yesterday or 10 years ago, I still retain those First Amendment rights whenever I do choose to exercise them.
If the telephone company decided that it didn't want to carry really terrible speech, says from now on, if you say something homophobic, we're cutting off your phone line, is that okay?
Well, Your Honor, we would argue that that's not quite the same as these social media platforms. These social media platforms are more forums for speech, holding out this forum, holding out the speech, showing it to users, rather than just conduits of person-to-person, peer-to-peer communication. However, if there were to be, and also furthermore, sometimes telephone carriers have been regulated as common carriers. There's a tradition behind that, whereas there's no such tradition for these social media platforms. I think it's important to focus on the particularized merits of this case to see what the qualities of these social media platforms are as compared to these telephone companies, which aren't necessarily good analogs to the platforms that we see currently.
You're bringing a facial challenge, though. If you're asking us to look at how these particular social media sites work, doesn't that make this a much more fact-intensive case and not one suitable for a broad brush when we don't know how every potential site affected by this really works?
Well, Your Honor, we'd like to say that we also bring a facial challenge under the notion that much of this bill is politically motivated, in the sense that we've proven that governor, lieutenant governor, and many key figures in the state senate as well that have pushed for this bill have done so from the perspective of wanting to limit political speech on these platforms. So we think that that also does paint a broad brush in the scenario that would basically make it so that any speech that would be tried to regulate it by SB 7072 would be unconstitutional.
Can a signing statement change whether a law is constitutional or not, even if the text is exactly the same?
Actually, yes, Your Honor, it could hypothetically do so. So as held in Rosenberger and Turner, regardless of whether or not a law may seem valid facially, if it is motivated by an unconstitutional and impermissible purpose, in this case being the suppression of what is perceived to be left-leaning social media companies. It's unconstitutional to put forward that bill where your interest is just a suppression of speech. And even O'Brien said that it had some rhetoric about, not picking and choosing what happens in the legislative history as justification for overturning a law. But even O'Brien said that the interest of the government in regulating speech had to be unrelated to the content of the speech itself, which unfortunately in this case, Florida's interest is 100% related to what they perceive to be as a liberal bias.
How do I figure that out? I'm sorry, how do I figure that out? If the governor is smart enough not to put it into the signing statement, but he gives a press conference, is that enough? I mean, how many legislators need to say that this is their motivation? There are other legislators who said this is a consumer protection law. Like, what's the standard for applying this motivation test?
Well, Your Honor, when it comes to some of the consumer protection concepts, I imagine that they're hiding behind some of the antitrust provisions also contained in the bill, trying to paint this as just, an overall consumer protection thing. But the author of the bill, the sponsor of the bill, said that this was for the purpose of regulating the speech. The governor, when he signed it, said it was for the purpose of regulating the speech. The lieutenant governor said it was for the purpose of regulating the speech. Many of the members of the majority caucus in the Florida legislature said that the reason that they were voting for this bill, the reason they were putting forward this bill, is for the regulation of speech. If they had hid that motivation, sure, it would be much harder to actually discover their impermissible purpose. But luckily, in this case, we don't have to worry about that. They made it quite clear why they created this bill and who they intend to target.
Counsel, a moment ago, you were talking about regulation of speech just now, but you called it earlier suppression of speech, and I don't see how the platform's speech is necessarily being suppressed here. After all, I mean, the platform, even if it's required to not discriminate in taking down messages, it can always make its own views clear. It can always state what their values are. It can react, presumably, to different people's posts. Maybe, I don't know if there's anything in this statute that would stop them from sort of flagging or somehow automatically responding to posts that they don't like to make clear they don't agree. Isn't the platform's ability to express itself completely preserved by this? And the only thing this law does is stop suppression of other people's speech by this platform. I mean, where's the suppression of speech going on here? I don't understand that.
Your Honor, actually, this bill does prevent some kinds of notes or flags from being added to posts. One of the provisions is that there can't be some kind of disclaimer. So you do actually have this kind of pervasive intrusion on the speech rights of these companies. And furthermore, Your Honor, a limited amount of speech is not a good replacement for the full exercise of one's rights. As we presented in our brief, saying that a student could wear a black sticker in school, it's not a good replacement for allowing them to wear a black armband in school. Or saying that protests outside of a soldier's funeral could be moved somewhere else. You can't replace speech one for the other. When someone has a right to exercise this speech, to say that it's only partially limited, or to say that they retain some of their rights, we don't think is a proper characterization.
Counsel, I'd like to ask about the transparency provision. You said during your opening statement that your explanations are not going to be factual and uncontroversial because they have to be thorough. I don't see the connection there. Just because you have to be thorough, that doesn't mean it's not factual. You're just being asked to explain the application of your terms of service. What's the problem with that under Zouderer?
Well, Your Honor, I can answer that. We think that many of these restrictions are unduly burdensome, as we've stated, because in the most surface level thing, they require personalized messages for many of these companies, which to the tune of, if you're regulating tens of thousands of messages of content, then that means that many of these companies would have to create whole new divisions that would service these complaints as well. And this would also harm many firms that wouldn't be able to facilitate this to such a high level. So we think that is unduly burdensome there.
So I'm sorry, is that a shift to saying that Zouderer does apply and this law just fails that test? Because I was asking about whether it meets the Zouderer test to whether it fits, I should say, within the Zouderer test to begin with.
Well, Your Honor, we do think that this is, because it is a compelled speech requirement, regardless of whether you're going for them or for us, it's still compelling that these companies produce some kind of speech. But we would say that it's not purely factual because the standards of the bill are so broad. It requires that they be precise and thorough without actually defining what those descriptors mean. Meaning that if this were ever to go to trial, if someone's speech, let's say that someone's speech were to be regulated, were to be moderated, and they were to receive a message and they were to say, oh, this isn't thorough enough, this isn't precise enough, and they were to go to court on that, it's not uncontroversial as to what thorough is and what precise is. You can't expect a company to meet those requirements if you don't actually tell them what those requirements are. And in comparison to something like a numerical, something like a statistical analysis, those are factual things, those are uncontroversial things. But the bill's requirements are far beyond that and are impermissible compulsive speech.
Thank you, respondents. Petitioners, 5 minutes for rebuttal.
May it please the court. We'd like to go through respondents' principal arguments that the law firstly infringes on the expression and editorial discretion of the social media platforms, secondly, compels speech unconstitutionally, thirdly, is not a common carrier regulation, and lastly, is invalid due to its discriminatory intent. At the very beginning, I want to talk about how they characterize Fair and Pruneyard incorrectly. Fair expressly rejected that it was deciding the case on federal funding grounds, and in Pruneyard, Justices Powell and White did note that the mall owners didn't allege that they objected to the ideas contained in the appellee's petitions, but that the owners didn't claim that some likely future speakers would express views that would be so objectionable, but the majority didn't rely on this premise at all. So this court should not mischaracterize previous precedents in order to rule for respondents.
So going to respondents' point on Halleck, they cite Halleck as saying that when a private entity provides a forum for speech, they may thus exercise editorial discretion over the speech and speakers in the forum. But I think it's important to point out the context of Halleck. This is not saying that such a private entity has a right to exercise editorial discretion, but just in the absence of any law stating otherwise, the default is that they have this editorial discretion. And so Halleck is really inapposite to the context of this case here, because Florida's SB 7072 essentially changes that default of having editorial discretion, which
Counsel, I'm sorry, I don't understand. It's right there in the case. It says editorial control is an aspect of the First Amendment. Why can Florida pass a law and abrogate the Constitution?
So Your Honor, Florida is not violating the Constitution and its law here. The important thing to note is that editorial discretion is not really present here. I suppose what Halleck really gets to is the idea that a private forum it has the capability of exercising editorial discretion over a forum that it controls, but that's just not what's happening here. And so the facts of the two cases just don't line up exactly. Here, social media corporations are not exercising editorial discretion in the way that was exercised in Halleck. As the platform said in Gonzalez and Tamina, they don't know everything that's on their platforms. They don't edit everything that's on their platforms. And I mean, ISIS was on their platforms. They had not the slightest idea and took no action. So it's kind of odd to think that they're exercising editorial discretion while being completely oblivious to much of what.
Well, counsel, surely you admit, I mean, there are some cases where they look at specific content and make an editorial judgment as to whether they want that on their platform. Surely that happens on the platforms, right?
I think the difference, Your Honor, is that would be back end, whereas the cases recognizing some sort of editorial discretion are on a front end basis, like in Tornillo or in Hurley. So it's an entirely different universe. But moving on.
So really, like the case would be totally different if it just had to pass through before it goes up, like it passes through somebody. It's only because it goes up by default that you're saying there's no editorial discretion?
I think that's right, Your Honor, because when you're dealing with a newspaper, for example, everyone who's in a newspaper knows that what the content they're reading was approved by somebody else. That's not at all how social media works. Social media is supposed to be the modern day public sphere, as this court recognized in Packingham. And for Section 230 purposes, that's how these companies represented by respondents hold themselves out. So they're speaking out of both sides of their mouth, as I said before. This court can't indulge all of the different ways they try and gerrymander how they act for one purpose as opposed to another. They've represented last year in Tamna that they have no sense of what's on their platforms. This court to take them at their word that they are not editors in any meaningful sense.
So in the future, if a print newspaper uses an AI to be make its editorial decisions of which op-ed to publishes, it loses its First Amendment rights?
I think, Your Honor, that the difference between some sort of algorithm, that raises different tricky First Amendment questions that I don't think the court needs to wrestle with in this case. But also these respondents assert in Tamna that their algorithms work like the Dewey Decimal System, that they're entirely content neutral, message neutral. They're not expressing any sort of message at all. So on the issue of algorithms, respondents have absolutely nothing on that point either, Your Honor.
Twitter seems pretty different now since it turned into X and Elon Musk buy it. Doesn't that show that there's real differences depending on the choices these platforms make?
So, Your Honor, I think what that gets to is the platforms are changing in the way they might run their business, but it's not expressing a different message necessarily. As Twitter, no clear message could be inferred from. Pardon, I recognize time's up.
You can 2 more sentences.
All right, thank you, Your Honor. So with Twitter, there was no clear message that could be determined, and with X, there still is no clear message that can be determined. So therefore, even though the style of the business may have changed, there was no message before, and there still is no message now.
Thank you, petitioners. The case is submitted.
Right. All right. So everyone, please come back on camera. Let me be the first to congratulate you. That was a very well done match. I've had the privilege of judging these 4 students now for several rounds, and as good as they are today, they've actually made significant improvements, both in their polish, their etiquette, and also their substantive knowledge of the case. I have to sort of pinch myself, remind myself that these are 16 and 17-year-olds doing this and not, partners at law firms. This was a very impressive round. I've given you all the feedback in the world, so maybe if I can go to Tommy and Corbin and Jacob, if they can have some feedback as well to share with the students. It's just, this is a very good learning experience.
Yeah, sure. I'll go first. Man, I echo everything Josh said. Honestly, you guys, I've seen law school moot courts, and you guys were at that level for real. So I'm just blown away. Mainly positives for all of you. I mean, you knew the cases well. You knew what your best points were. You knew what your kind of where to shift the argument, or if you're on the back foot a little bit, you immediately had something to call to mind. And it's just clear that you all really prepared a ton of hours into this, so you should all be really proud to get to this level. All teams looked super professional, more dressed up than I am, or than I looked in a lot of my law school moot courts as well. So I'm really impressed by that. I think you both had themes that you really kind of understood, like the full argument is really going to be pushing a particular theme, and you're going to keep coming back to that in a way that I thought was effective. Petitioners, you had this theme about they don't have a message, and respondents as well. I think you hit on sort of the core of editorial freedom and the precedents that were really strong for you. A lot of it, my only sort of criticisms would be really nitpicks more than anything. Petitioners, I think it's always a tough balance to draw. I think in a few points you might have talked almost too fast, and I hesitate to say that because I know this is a really restricted time limit, and so you want to get as much substance out there as you can. But on the flip side, the best oral advocates really are kind of have a conversational tone, and it's almost, and when you speak a little bit at a more conversational speed, it's both easier to, as the listener, to make sure you catch all of it, and it also sort of puts you more at ease and feels like it's not adversarial so much as you're kind of having a conversation and helping the court. Respondents, I did note it's in some points of your opening, you could sort of tell that you were reading rather than kind of speaking just from memory. It was still a well done presentation, but I think to really sort of make it most polished would be if you had it by memory and kind of not necessarily ad lib a little, but make it just seem like you're delivering it off the cuff, even if you really rehearsed it over and over again. And what would I say? I would say respondents, there are a couple times where, so for example, when we asked about, is it a problem that this is a facial challenge because there are differences in the different platforms, you immediately pivot to the signing statements and the intent behind it. Now, it was smart to bring that up because that does help your case for the facial challenge. But when the very first response is just pivoting to that, it almost seems like you're conceding. You should also have a response. You shouldn't seem like you're conceding the first point, the problem with the facial challenge, because the platforms are different. Because if you just pivot to a totally different argument to justify your facial challenge, then we're left wondering, okay, have they kind of admitted that all of the differences in the platforms is a problem for a facial challenge based on what it's doing to these different platforms? And last, just nitpicky thing I noted was response. There were a couple times where to start your answer, you would say something like, well, we would like to argue that XYZ. And I sort of stylistically, that's kind of throat clearing. It's you can cut it out without any change in the substance. If you find yourself wanting to say, I'd like to say, or we would like to submit, or something like that, just mentally cut all that out and start right with what you would like to argue. But that will come with practice. So great job to both teams.
And by the way, at the final round, if either of you should advance, no reading. You might have some lecture notes at the podium, but no reading. When you're on Zoom, it's harder to catch. But I think Tommy has eagle eyes, and he got that one right away. So, but good comment. Corbin, any thoughts?
Yeah, that was fantastic. I feel a bit sheepish giving any kind of feedback to people who did much better than I would have done in a high school moot court competition. Just really fantastic, good eye contact, good energy. As Tommy said, it's very hard, but I thought your pacing on the whole was excellent. Petitioner, I thought it was a very well done. One thing that's for the advanced course is the ostentatious concession. When somebody says, can you pass strict scrutiny? And if you think you can't, you go out there and say you can't. That was very well done and well conceded. You passed the master's course there. Bringing up Tomna, I thought that was very well done. One bit of advice, again, this is for the master's course, so I didn't call you on it in the argument. You need to be careful about the posture of cases that you rely on. This is like deep law school stuff and you're in high school, but like if something is on a complaint, so a party may have to accept certain allegations as true. So you need to be careful about saying what a party admits. So tech companies aren't necessarily admitting to things that occurred in Tomna. They just have to accept that what's alleged against them is true for purposes of the posture of the case. At a general high level, and this is so hard when you've got two teammates, but yeah, as Tommy was saying, you need to be careful about making an argument, getting a question, and then in response to the question, sort of pivoting to a totally different argument. And that's something that just comes with time. But at a high level, I would say that's just something worth concentrating on. Reading off of scripts, I was also going to mention. And then my final one, just a pointer for petitioner. In your opening statement, the order in which you choose to do arguments is always very important. I think generally you've got two questions presented, and what you probably want to do is deal with your content moderation topic and then deal with your transparency, the second question, rather than do some content moderation stuff and then do some transparency stuff and then move into common carrier and like other content moderation issues. So it's worth, especially in the opening statement, putting a lot of thought into the ordering of your arguments in a way that's sort of best coherent and works through the case.
Jacob?
Yeah, this was just a really amazing performance from all of you. I'm just extremely impressed, as the others have said. I've heard many law school appellate arguments, and many of those were not nearly as good as what I heard here just now. It really is impressive. And I agree with all the praise and criticisms that we've had so far. I don't have a whole lot more to add. With the petitioners, I did have the note also that the speaking is a little fast, and of course that gets to be a little hard to keep up with. I think it's something that people who have been practicing law a long time still have a tendency to do and still have to kind of reel themselves in on. The best advice I've seen on that is to just talk so slow you're sure you're talking too slow, and then you're talking at the right pace, because otherwise it's just too easy to be talking too fast and not realize it. You got to be conscious of talking slow, I think, and that does sacrifice. And it, I don't know if it affects this. If you need to get your points in for your score. I forget if that's part of the arrangement here, but better to make the points clearly than to cram more in that are kind of blowing past people and they don't have time to process. I thought, in general, the critique about pivoting aside, in general, I thought you all did a great job in listening to the question and answering the question that was asked. And I was just super impressed by how you had ready answers, whether it was something factual or something legal. You were ready to go right into an answer, sometimes like a multi-part answer that was just well organized, the points laid out well, made very clear, very well done in that respect. On the rebuttal argument, it seemed to me, I appreciated the effort to sort of give a roadmap, a preview of where you were going with the rebuttal. But in doing so, if I recall correctly, it sort of laid out the points you were going to be responding to one by one. And that isn't, just laying them out doesn't really have any persuasive value. And then also, of course, on this short rebuttal, you're eating up your time. I, on a rebuttal, would be more inclined to just go for whatever you think the most important thing is and hit it directly in persuasive language from the outset. And then if you have time to hit the second and third or fourth most important things you want to hit, get to them. At least that's how I would do it. But again, all of this, as somebody else said, I feel weird even offering criticism because it was so impressive. Great job.
I'm past that point. I've heard these students do this for the years, so I don't have the compulsion.
Yeah, right.
Because
the next round won't have the benefit of my shock, I guess, at how great high school students can be.
Right. As good as these students are, they do get better from round to round. And I sort of view these sort of moots as like hazing exercises where you kind of get beat up a little bit. And then you go back and you rewatch the video and, oh, I should have said this. Oh, I could have said this. Oh, and I missed this, right? That's any advocate will tell you that going back and watching the video, it's cathartic and infuriating. It's like, oh, I should have done this, and why didn't I say that? And I could have gotten this point in, and oh, the judges should one more second and another sentence, and then so on. Okay, but yeah, this was a strong round. I'm not quite sure how we're going to pick the winners. We have another round starting in about 15 minutes or so. So I do want to give a chance to the students to ask questions of the judges or us for anything about law school. That being these are actually all public interest lawyers. It wasn't sort of deliberate, but that's sort of just how it shook out. Any questions about litigation, whatever you have in mind?
If I may ask of the three judges, were any of you at the Moody versus Net Choice oral arguments?
I was.
Oh, you were there. Cool.
Yep. Got in the fourth in line in the SCOTUS bar line.
What time did you get there in the morning?
6:45.
That's not bad at all, actually.
Yeah. That bar card does wonders.
Was there anything, Tommy, if I can ask, not to cut my students off, is there anything that you observed in the courtroom that may not have been reflected in the audio recording?
Yeah, when Justice Alito said he thought that calling this content moderation rather than censorship was Orwellian, you could immediately see Justice Kavanaugh lean back and laugh, and he leaned to Justice Kagan, who's just to his right, and started whispering back and forth with her, and I could tell he was saying like, "Oh man, I'm gonna ask a question that rips into Alito." And then, of course, next time he asked a question that was really just a really long statement about how Orwellianism is about government, not private actors. And in general, Kagan and Kavanaugh seem to be very much on the same page and teaming up with each other and passing a lot of notes and remarks back and forth.
If I could just ask one question about the amicus brief writing process, since there are so many different provisions of the law and so many different issues at play, how did you all choose to focus your amicus briefs and go about drafting them?
Good question. Jacob,
Tommy, you had a very niche, excellent sort of precision strike brief. So I think you should go.
Well, it all goes back to as a 3L in law school when in 2016, when net neutrality was the big thing, and all of the liberals were defending it based on this case called Pruneyard, and all the conservatives were criticizing it and saying that Pruneyard was a violation of the free market and the First Amendment. And I agreed with the conservatives back then, and I had a seminar with Professor Barbara Van Schevick, who is one of the biggest defenders of net neutrality, and had a bunch of debates with her. And I thought, one day I want to write like a student note or something about how bad Pruneyard is from a libertarian point of view. Little did I think 8 years later, I would still think the same thing about Pruneyard, but all the conservatives and liberals would switch sides on it. And so that basically was my motivation to be like, well, at least somebody needs to be consistent about the libertarian problems with Pruneyard, so might as well be us.
Yeah, for us, we had been involved in suing Facebook and Twitter for censoring our client in collaboration with the federal government. And so we thought it's important to make clear that government-backed censorship is a problem. Of course, that's being taken up in the Murphy case. But also, it would also offend the First Amendment to force platforms to host things they don't want to host. And the real solution for all of this is to just get government out of it. We kind of wanted to round out that picture and tie in Murphy and show how the court should be consistent in applying First Amendment principles across both of these cases.
Our organization, going back to Tommy's point, has a background in what is now the deep history back like 2017 of net neutrality. We talked a lot about common carrier law in that context. And we actually filed in the district court when this was when the lawsuit first happened, and in the Court of Appeals and in the Supreme Court. So at the time, when we wrote version 1.0 of our brief, there hadn't been much discussion of common carrier. So we thought we could bring in some expertise with this sort of arcane and mysterious topic. And since then, there's been so much other discussion of it, and we've kind of, stuck with that topic. But at the time, we thought we were being sort of super niche, and then it sort of grew up around us.
Mr. Barthold, if I may ask, what do you define a common carrier as?
How much time do we have?
Yeah, the mysteries of common carrier law. I mean, the short answer is you can go and check out our brief at the Supreme Court. I think the one you have linked on the website is actually what we filed at the cert stage, which is about Zouderer. But if you want to talk about, an entity that carries stuff, commodities from point A to point B and holds itself out as such, and I would prefer to throw in there that it has some kind of bottleneck control over its avenue. But the fact is, Blake Reed actually has a great article in the Stanford Law Review called Uncommon Carriage, talking about how the fact that it's an onion. You peel all the layers and then you get to the bottom and there's nothing there. There is no agreed upon definition. So actually, it's unclear what that concept is doing in a discussion of the First Amendment, or why you could take a common law concept, which common carrier fundamentally is, and let judges expand it at the expense of the Constitution. So I apologize. It's very much a non-answer, but there you have it.
All right. What other questions we have?
I guess one thing I was curious on, and I know perhaps this is just asking for some speculation, but what are you sort of predicting for the Supreme Court's eventual decision on this in terms of the split and what the majority and dissent might sort of pull out for their positions in this case?
Walking predictions. I don't know. I'm actually I've been asked this question by the press. I think Florida loses. I just don't know how. If that makes sense. I don't know. Tommy, Jacob, and Corbin, what do you guys think for predictions?
Yeah, I think Roberts shooting down Rumsfeld, Sotomayor shooting down Pruneyard, Kagan, Kavanaugh, pretty clear to me where they are. Barrett at one point seemed sympathetic to Miami Herald versus Tornillo applying here. I think those are your 5 votes to get a ruling against Florida here. The question is, how far will they go? Will they just sort of yell editorial control and go home? I don't think they will. I think Barrett and a few others were very concerned about a ruling that will have more of a scope than they want. So I think those 5 at least, with a narrow win for net choice.
I'm gonna plug Corbin's appearance on a panel we had at Cato Institute. I just put it in the chat where we all gave our prognostications, and Corbin had a very detailed account for every single justice. But watching the whole panel, I recommend. All the panelists were excellent, including someone on the team, on NetChoice's litigation team.
Well, thank you, Tommy.
Yeah.
Corbin's guesses sound promising to me. I don't have any prediction of my own. I really don't know how it's going to go.
Tommy, what's your prediction?
Honestly, I think they could. It seemed like in the Florida law, they were seriously considering punting it, like maybe even certifying to the Florida Supreme Court to ask, what does this actually do? They seemed genuinely confused and concerned about what exactly it affects, Barrett and Jackson in particular. So I think it's a wild card, but that was what the Solicitor General suggested when Gorsuch asked. She said you could certify it.
Because Twitter threads are obviously where all the deepest analysis occurs, I will put my thoughts on that in here.
All right. We have the other round starting in a few moments. We'll make sure we give everyone a little bit of a break. Let me turn the recording off. Say thank you very much to our judges, and we will start the next round in a couple minutes. And to the students, we'll have results, I think, probably later today. I know you're in suspense, but I have to wait judges around for it. But thank you all. You all did exceptional, and I'm very optimistic and hopeful for the future of Republic if you have lawyers arguing. Thank you.
Thank you much. Thank you very much to all the judges. It's been a very fun argument, and definitely appreciate your feedback and critique on everything.
Okay.
Thank you so much. Take care.
Thank you.
Thank you, Professor Blackman.
Thank
Thank
you.
you, judges.